We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that...
The speaker pauses, clearly confused, and questions what freeze is even supposed to mean in this situation. The remark suggests disbelief at the other person's behavior, implying it makes no logical or legal sense. There is a strong tone of frustration, as if the actions being discussed are disconnected from reality. The commentary then shifts to a sharper critique, questioning whether the individual fully understands the seriousness of the moment. The behavior is described as so irrational that it raises concern about the person's judgment and awareness during a formal legal process. This moment highlights a breakdown between expectation and reality in the courtroom. Finally, the speaker points out that writing a statement on the outside of official legal documents does not carry any legal authority. Simply marking a discovery packet with a personal rejection does not invalidate the process or remove responsibility. The situation is framed as a self-created legal problem, one that cannot be avoided through symbolic gestures or misunderstandings of the law.
One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor,
you don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or...
The speaker questions whether the individual truly understood what was contained in the packet they chose to reject. That packet was not a formality or optional paperwork. It was the foundation of the entire case. By refusing it, the person turned away crucial information meant to protect their own interests. Declining the discovery materials is portrayed as a serious strategic error. These documents typically outline the exact accusations, the timeline of events, and the evidence the prosecution plans to rely on. Without reviewing them, the defendant remains unaware of the case being built against them. As a result, the individual now faces the possibility of going to trial unprepared. Entering a courtroom without knowing the specific claims or evidence places someone at a major disadvantage. The commentary underscores that understanding the case is not just helpful, it is essential for any meaningful defense.
Just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
I'm going to mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this. This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
That conclusion comes as no surprise at this point. The speaker makes it clear that they have little confidence in the individual's understanding of even basic procedures. The concern being expressed is not personal, but procedural and practical. The commentary suggests that the individual appears overwhelmed by simple tasks, especially within a structured legal setting. This raises serious questions about their ability to follow instructions, process information, or make sound decisions under pressure. In a courtroom, those shortcomings can carry real consequences overall. The statement underscores a broader issue. A lack of preparation and comprehension can quickly compound legal problems. When someone struggles with fundamental responsibilities, it becomes even harder for them to navigate a complex judicial process effectively or protect their own interests.
I'm muting Mr. Hurst, and I will let Ms. Strickhart say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhart, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
The speaker emphasizes this point with firm certainty, making it clear that this is not speculation but a conclusion based on repeated patterns. Individuals who follow sovereign citizen ideology are often viewed as financially unreliable within legal and commercial systems. Their rejection of established laws and contracts creates ongoing complications. From a financial standpoint, engaging with such individuals is widely seen as a high-risk decision. Businesses, institutions, and even private parties typically avoid any formal agreements because these interactions often lead to disputes, unpaid obligations, or prolonged legal challenges. The lack of mutual recognition of legal authority makes standard transactions nearly impossible. As a result, most financially responsible parties choose not to enter contracts at all. The commentary highlights that trust, accountability, and adherence to legal frameworks are essential for any agreement to function. Without those elements, partnerships collapse before they ever truly begin.
I know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you.
The speaker frames the situation as a choice entirely of the individual's own making. If someone insists on taking actions that harm their own future, that decision ultimately rests with them. There is no outside force compelling these choices, nor is there an obligation for others to intervene. The commentary goes on to suggest that this behavior places the individual outside the concern of most reasonable observers. When someone repeatedly ignores guidance and established rules, responsibility shifts squarely onto them. At that point, consequences are no longer surprising. They are expected finally. Attention turns to the courtroom itself, where the judge is portrayed as fully aware of the situation. Rather than being persuaded, the court is likely to see through the arguments with ease. By the end of the proceedings, the individual's claims may be met not with sympathy, but with clear dismissal, and perhaps quiet disbelief at how the situation unfolded.
I had a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right,
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
Okay,
they can't
so
tell you.
she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't
discovery
interrupt me again. We had this conversation before, didn't we?
Sorry.
We
Go
had
ahead.
this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
The situation is similar in some ways, but there is a key difference that cannot be ignored. Unlike a trained legal professional, this individual does not have years of formal legal education to rely on when attempting to defend their own case. That lack of training places them at a significant disadvantage from the very start. As the first court appearance comes to a close, one important development finally occurs. After initial resistance, the individual agrees to accept the discovery materials. This moment marks a shift, as the process can now move forward with at least some level of procedural compliance. With that stage completed, attention turns to what happens next. The case progresses into the second court appearance, where earlier choices begin to carry visible consequences. From this point on, the courtroom dynamics change, and the outcome becomes easier to anticipate as the proceedings continue.
21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
Was that?
It looks like this.
I'm asking you
Yeah.
first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay, July
Thank
26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
At this point, the individual is about to face the consequences of their earlier decisions, and the courtroom is bracing for what comes next. The upcoming sequence of events has been hinted at throughout the case, building anticipation for a particularly revealing moment. The speaker emphasizes that this is where the situation becomes most interesting, not because it benefits the individual, but because it highlights the courtroom dynamics in action. The judge, in particular, is expected to respond sharply as the proceedings unfold, with reactions that underline the seriousness and sometimes absurdity of the choices made. This is the moment where the procedural drama becomes most apparent. Every decision, every misstep, and every unprepared move comes into focus, giving observers a clear view of how legal processes respond when someone is caught unprepared or acting against standard protocols. It's a vivid reminder that the courtroom always notices when rules are ignored or misunderstood.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
I have to admit, I watched that moment on repeat, and each time it had me smiling even more. It's one of those rare moments in a courtroom that's as fascinating as it is surprising. Honestly, it just keeps getting better the more you watch. That wraps up today's breakdown. If you enjoyed this video, give it a like. If it wasn't your cup of tea, feel free to leave a dislike, but make sure to share your thoughts in the comments below. And don't forget to subscribe and turn on notifications so you never miss a video where we dissect courtroom moments, legal drama,